the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3166, United States of America versus Darrell Neely, appellants. Mr. Ancina for the appellant, Mr. Hill for the appellee.
Morning, Your Honors. May it please the court. I'm Paul Ancina. I represent the appellant, Darrell Neely. Mr. Neely is a journalist who hosts an online news show, and it was in that capacity that he went to the Capitol on January 6th to observe and report. He did not bring any signs. He did not wear any kind of equipment. He did not bring any weapons. As I said, he was there to observe and report.
What relevance does that have to any of the legal issues we are resolving today?
It has no specific relevance to the legal issues, Your Honor.
All right.
After January 6th, Mr. Neely was interviewed twice by the FBI. Both cases, he cooperated fully, answered all their questions, and even supplied them with evidence. Several months later, he was arrested, and he was met with agents who engaged him in a conversation. After that conversation, he was given his Miranda warnings, and then they conducted a videotaped interrogation. He was charged with 6 crimes, went to trial before Judge Bates, a bench trial, was acquitted on 1 crime, one allegation, that's civil disorder, but convicted on the rest, and he was sentenced to 28 months in prison altogether. I've raised 3 issues on appeal. First, the district court erred in denying the motion to dismiss counts 3 and 4. Second, the district court erred in denying the motion to suppress the interrogation. And third, the district court erred in denying the motion to transfer venue. And I'd like to start with that third point, the motion to transfer venue. Several months ago, the government filed a Rule 28J letter with the court regarding this court's decision in United States versus Webster, number 22-3064, where the court rejected a similar venue challenge. In that case, the court held that the court rejected the argument that the entire jury pool was presumptively prejudiced against the defendant in that case. And that is an argument that we made here, and that is addressed by the Webster court. However, the Webster decision leaves open several of our arguments. In order to determine the presumptive prejudice of a jury pool, the court looks at a number of different factors. One is the size and characteristics of the jury pool. That, I believe, is foreclosed by Webster. But the others are the nature and extent of pretrial publicity and the proximity of time between the events and the publicity and the trial. Now here, what's different is that the nature and extent of pretrial publicity are different because in Webster, the court held that January 6th coverage generally is not sufficient to create that presumptive prejudice. However, in this case, appellant Mr. Neely was singled out, and Rolling Stone published an article about him that was incorrect, that alleged that he was selling souvenirs from January 6th and that he had smoked marijuana in the Capitol.
Why can't that be addressed in voir dire? If there's usually a question of the veneer panel, have you heard any coverage about this case? And if they answer yes, you can follow up and you could adjourn for that reason.
That particular issue, I believe, can be addressed in voir dire. But the other issue is that the question of the proximity between the publicity and the trial. Here, what happened is Mr. Neely's trial was 2.5 years after January 6th. And in Webster, the trial was a year after January 6th. Now, you might look at that and think, well, gee, this is even more time that's elapsed, so that's an even weaker argument. But here, Mr. Neely's trial occurred in the middle of the televised hearings by the House Select Committee on January 6th. And in the passage of time here between January 6th and the time of the trial exacerbated the prejudice here, because if you look at what happened with—
Did he object on that basis in the court below? Did he make a motion based on the January 6th hearings? Because that's different from general publicity about January 6th.
Well, it is. And the argument I'm making is not based on the publicity from it, but on the proximity of time.
And did he object on that basis that this trial is happening while these hearings are taking place and therefore it's unfair to me?
Your Honor, I'm afraid I can't answer that question right now. I don't know the answer whether he specifically objected on
But
that
do you agree
issue.
that he would have to specifically object to that in order to rely on it here?
I think that unless there were clear error,
Or plain error?
plain error, I'm sorry,
Okay.
plain
thank
error.
you.
But even if, let's assume for the sake of argument that he made that specific objection below, why isn't that also something that can just be taken care of in voir dire? I mean, we've had trials in this courthouse relating to Watergate. We've had trials in this courthouse relating to Iran-Contra. Lots of things where there have been televised congressional hearings, front page news, et cetera.
That is correct, Your Honor. But those events like Watergate happened 50 years ago. The Iran-Contra scandal took place 40 years ago. The news media ecosystem is different today. It is all-encompassing. It is 24/7. It's constant. And January 6th has been in the news every day since January 6th. And the January 6th hearings were a huge event. I believe the first hearing drew something like 25 million viewers, which is something like not Super Bowl caliber, but along the level of, say, a Monday Night Football game, which is a huge number of people. And the statistics show that DC residents pay more attention to January 6th than other people. So in all likelihood, a much greater proportion of DC residents watched all those hearings. And Mr. Neely's trial occurred after 8 of those televised hearings and before the 9th. So in that situation, I think Webster is distinguishable because when Webster went to trial, it was in the early stages of January 6th. A lot of people were talking about things like it was just a slapdash, haphazard event that just kind of got out of control. But what the January 6th committee hearings did was they threw cold water on that, because what they conducted a detailed forensic analysis of everything that happened. They had thousands of witnesses, thousands of documents, and they talked about all the extensive violence that happened that day, conspiracies, activity to undermine democracy. And I would submit that those events exacerbated the privilege, even though more time had passed.
What evidence was put before the district court in support of the motion to transfer venue?
Your Honor, I think that the motion to transfer venue raised the same issues I'm raising here today, which is that I think what it relied on primarily was the notion that the DC voir dire was overwhelmingly prejudiced against January 6th.
But I understand that argument, but what evidence was put before the district court? What evidence is in the record to support that argument? What polling data? What surveys?
Your Honor, the polling data took place, I believe the polling data took place prior to the January 6th committee hearings. So I don't believe that polling data supports this argument, frankly. And the polling data, I believe, at least one of the polls that the defendant put forward before the district court was expressly rejected by the Webster court.
I guess I think to me, one challenge you have is that, it'd be one thing if you had attempted voir dire below, you, meaning Mr. Neely's counsel below had attempted voir dire, and we're having trouble finding jurors, or there was some polling or survey data that demonstrated it would be difficult to find a fair and impartial jury pool. But if the data that was put before the district court is not really materially different than the data that was put before the district court in Webster that we rejected, I'm not sure how do we get around that?
Your Honor, I think what does distinguish this case from Webster is the timing of the trial. And that was before the court in the sense that it was occurring when it was occurring. The court knew that those hearings had taken place. That's all I
I
can say.
understand.
I'd like to turn, if I may, to the motion to dismiss, and specifically the second argument I raised in that. I made two arguments on the motion to dismiss. One was that the statute requires that the Secret Service restrict the area. But the second argument I made was that even if the statute could be read as allowing anybody to restrict the area, it was still vague, still unconstitutionally vague, because the history of the statute, this statute has never apparently been used to prosecute anyone for entry or remaining into a restricted area that was restricted by anyone other than the Secret Service.
You know that.
Well, I've looked and I have found nothing.
It's just, I don't know that it's normal to be researching who restricted what as a prosecutor bringing one of these charges. Like, I just don't think that would be something you'd be thinking about. Well, who restricted this area?
Well, it's like what happened in the Bowie case that I cite, Bowie versus City of Columbia, where the protesters came into the restaurant and then someone hung up a no trespassing sign. And the statute said trespassing means entry into a place. And the court said you can't prosecute these people for trespassing because A, the statute doesn't cover it, but also the court explicitly said this interpretation, the interpretation given the statute by the South Carolina Supreme Court, had not the slightest support in prior South Carolina decisions. Now, there are no decisions that I could find that.
But just because there are no decisions you could find doesn't mean that they've never brought a prosecution.
Well, that's why I said
that was not.
That's
whatever.
That's why I said apparently. Okay. Because.
Well, why do we need to pass the words of the statute in this instance? It doesn't say that it has to be.
Well, Your Honor, I do think that the statute does address it. In fact, if you look at the only court that's addressed the issue, the Bursey case, that court read the statute as requiring Secret Service restriction.
Well, that was a very different factual situation. Let me ask you, what about the evidence in this case that the signs that were posted did refer to the Secret Service?
Your Honor, I see that my time.
You may answer my question.
Thank you. Well, even if the signs referred to the Secret Service, the fact of the matter is that the statute requires that the property be restricted by someone. And here the restriction was not put in place by the Secret Service, even if the signs.
Well, the statute is silent. Would you agree with that?
The statute
is. The text of the statute.
The text of the statute, as the district court said, the text of the statute says nothing about who must do the restricting.
So your client enters this area where the signs are posted and it refers to the Secret Service. What more was required under this statute?
Well, Your Honor, I don't believe that factually that there is evidence that the signs were up when my client went in, because those signs, there's evidence in a lot of these cases that those signs came down, they were trampled.
Well, the fact that the rioters trampled them doesn't mean, does it, that no one knew that it was a restricted area? That isn't the argument you presented, as I understand it.
Well, the argument.
The client was there, as you started to tell us, as a journalist.
Correct.
They were all over the place. Some signs were up, some signs were down.
Well, Your Honor, even if the signs had said this area is restricted by the Secret Service, that apparently would not have been correct, because the area had not been restricted by the Secret Service. It had been restricted by the Capitol Police.
Well, that's not the argument you made. That's what I'm trying to focus on. And I think that's what my colleagues have been focusing on too. In looking at the district court's opinion, we are, as are you, confined to the arguments and the evidence that was presented.
Yes.
So you say it was vague.
What I'm saying is that the statute required that restriction be done by the Secret Service.
But you have acknowledged that the statute does not say that.
The statute does not explicitly say that.
Correct.
So the statute says that it's a crime to knowingly enter or remain in any restricted building or grounds without lawful authority to do so, right?
Yes.
That's the text. So someone like Mr. Neely, where the evidence shows that he's standing in a crowd, and the crowd faces a police barricade, and they're pushing past a police barricade and passing the Trump 2020 sign down, basically using it kind of as a weapon to push back police officers. That person wouldn't be on notice that if they go past that area, they are entering restricted grounds that are being guarded by a police barricade.
But Your Honor, in that case, if the statute said that it was illegal to go past a police barrier or to knowingly go past a police barrier, they would be liable. But
Well, isn't that a clue that it's restricted if the police are cordoning it off and fighting physically to push people back from that area? Isn't that a clue that might be a restricted area?
But the question is, who restricted it? Because even if it's restricted by someone other than the Secret Service.
Well, I'm assuming we don't buy that argument since it's not in the text. Then what's left?
If you don't buy that argument, nothing's left, frankly.
All right, your time is up. We'll give you a little bit on rebuttal. Let's hear from the government.
Thank you, Your Honor.
Good morning.
Good morning. May it please the court, Dietrich Hill on behalf of the United States. To pick up on what the court was just discussing, I do think that the defendant here is asking the court to read into the statute something that just doesn't exist, which is a limitation that it only applies to restricted areas that have been restricted by the Secret Service. There's nothing in the statute that suggests or supports that. Instead, the statute applies to any area that has been posted, cordoned off, or otherwise restricted. Any is an expansive term, and the Supreme Court has said that any should be read expansively, and that courts shouldn't generally be reading other language into the statute. And as we've explained,
So let me ask you, that's not inconsistent, is it, with an argument that, yes, it may have been restricted and posted, but that was done by some entity that had no authority to do so?
well, I don't think the defendant here is arguing that the entity that restricted it, which at the very least was the Capitol Police, didn't have the authority. The question instead, I think there's no dispute that the Capitol Police had the authority to restrict any part of the grounds. The question is just whether 1752 includes within its scope an area that's been restricted, certainly by the Capitol Police. And there's no reason to think it doesn't. That's entirely consistent with the language of the statute and its purpose, which, as the original Senate report said, is to extend a minimum of federal jurisdiction to cover any trespassing that threatens the president and subsequently the vice president or these special events of national significance.
So in this case, is your understanding of the record that the signs that were posted by the Capitol Police, having been advised that the Secret Service would be bringing the vice president to the Capitol for this official ceremony? And that's part A, and then part B would be, and the signs in fact referred to the Secret Service?
To part A, I believe the signs were posted by the Capitol Police, and yes, they were aware there was communication between the Secret Service and the Capitol Police, making clear that the vice president was coming and that the ordinary procedures would be followed, which include restricting this whole area. To part B of the question, I don't believe that the signs that were posted at the perimeter actually referred to the Secret Service. I believe the perimeter sign said area closed by order of Capitol Police. So the Secret Service issue would not have been evident to a person upon first entering the perimeter. But of course, the defendant here has not challenged knowledge that the area was restricted or knowledge that the vice president was in the area. So that's not
Thank
part of the challenge here.
Thank you.
With respect to the Webster issue and the change of venue, I would like to point out two things. One is that there's really no distinction here in terms of media coverage of Neely personally and Webster. Both Webster and Neely identified exactly two articles that referred to them and their potential involvement personally. And in fact, the articles about Webster referred to him at one point as an eye gouger, at another point noted that a prosecutor had called him a junkyard dog. So clearly there was some evidence that there could be personal knowledge or knowledge of this person's involvement. But again, as both of your honors have pointed out, the solution is voir dire to determine whether a juror is aware of those articles. And the second thing is that the court in Webster noted that before you even look at the dissipation of prejudice over time, it's the defendant's obligation to show that there's prejudice in the first place, which the defendant didn't in Webster, and we think Neely has not here either. With respect to...
What about the distinction that the trial of Neely did take place while the House Select Committee hearings on January 6th were taking place? That's different from Webster.
That is different. I don't think it's a material difference. I think at most it suggests that there could be less dissipation of prejudice, but I'm not sure. I think it could cut either way because, of course, as the defendant concedes, there was much less passage of time in Webster than in this case.
And this is a trial before the court.
And this is a trial before the court. Now, so the defendant here has waived any opportunity to go through voir dire and then argue that the jury that was in fact seated.
But he says he opted for a bench trial because his venue motion was denied.
That's right.
Yeah.
And we don't think that the defendant has waived the argument that the whole jury pool was so presumptively prejudiced that voir dire couldn't result in an impartial jury, but that's a much higher burden to meet than just trying to show that particular jurors could not be chosen who were impartial. As this court pointed out in Webster, the Supreme Court has only accepted a claim of pervasive prejudice that doesn't even require voir dire in one case. That's the Rideau case, which involved televising a murder confession repeatedly. So this case just is not comparable to that.
So as a matter of the record in this case, were questions asked about the hearings?
Were questions asked during trial?
No. In terms of the voir dire of the jury before the trial.
There was no voir dire in this case because the defendant...
Well, let me be clear then about the record in this case. I understood Judge Pan's question to say that Neely's position was he asked for a bench trial because he thought any pool would be so biased given the nature of the events here.
That's my understanding as well.
So here, and I realize this is outside the record, but presumably the court can take judicial notice or tell me if you think we can't. Not only were the television news programs continuously showing the events of January 6th, not only continuously, maybe for that week and the next week, and I mean, you could not escape it. So that is a different scenario, is it not? It's not the murder confession being shown every day, but this was clearly top line news in this area, and certainly on most of the national as well as the podcast events. I mean, the area was saturated with it, is what I'm getting at.
Yes, I certainly think any potential juror or almost any potential juror would be well aware of the events of January 6th. But as this court pointed out in Webster, that doesn't necessarily mean that any juror has formed a particular belief about this defendant. And of course, if a potential juror had such strong feelings about January 6th that they could not sit as an impartial juror, again, that's something that voir dire is designed to inquire about, such that, and the defendant's counsel would have the opportunity to explore each juror's view of January 6th. And this is outside the record, but certainly if you look at voir dires that have occurred in other January 6th cases, that's obviously a hotly contested subject because there is pervasive media coverage. With respect to vagueness, I did want to point out that Bowie is different in that in Bowie, the state court that the Supreme Court was reversing had effectively added language to the statute, had said, this trespassing statute that says you may not enter actually means you may not enter or remain. So by following the face of the statute, the defendants there had later been determined to violate the statute because it meant something different than it said on its face. Here, we're asking the court to apply the statute as it says on its face, and it's the defendant who's asking the court to interpret it to mean something different. So the defendant can't really claim to not have been on notice of what the statute said on its face. The other thing that I'd like to mention with respect to the meaning of 1752 in the restricted area is the very important context that in 2006, Congress added these special events of national significance to the definition of restricted area. Special events of national significance, by definition, involve many law enforcement agencies. And so it's not a sensible reading of the statute to try to add in this language suggesting that only a restricted area can only be set by the Secret Service. And Congress has specifically included areas that involve many law enforcement agencies. It would only be sensible to include all of the restricted areas set by those law enforcement agencies as well within the definition of restricted area. If there are no further questions.
Judge Rogers, do you have any further questions
No,
for
thank
the
you.
government?
Thank you. Then we would ask the court to affirm.
All right, thank you, counsel. All right. Mr. Enzina, I believe your time was up. We'll give you 2 minutes.
Your Honor, I'd like to start where my colleague started when he talked about the language of the statute. And he said that the statute says that it is meant to apply to any restricted area. That's what the statute says. The statute says posted, cordoned off, or otherwise restricted. And earlier, Your Honor asked me about, suppose a defendant comes up to a phalanx of police officers, and that's a clue to them that the area behind him is restricted. But let me posit a different scenario. Let's suppose you have a place like the hypothetical I've talked about in my brief about the Kennedy Center, a place where a Secret Service protectee is temporarily visiting, and parts of it have been restricted by the Secret Service. But you have one lone cop standing in a hallway, and he says to a gentleman comes up and says, I want to go down that hallway, and the cop says, you can't, it's restricted. Why is it restricted? Because I said it's restricted. Is that a violation of the statute? Under the government's reading, it is. Because the government says, the district court said, the statute says nothing about who must do the restricting. So
But doesn't it imply that whoever's doing the restricting had authority to do it?
well, that supposes that there's some authority that restricts the ability of someone to declare an area restricted.
Well, there are other statutes other than this one that confer authority on the Capitol Police, for example, to control the grounds of the Capitol.
Sure.
So you don't dispute that they had authority to restrict.
No, that's not my question. That's not my argument. My argument, though, is that under the government's reading of the statute, which is incredibly broad, any police officer can declare anything
Right,
restricted.
and
I can declare it
my
restricted.
question is, why is that an implication of the government's reading? It implies that whoever restricted this area had authority to do so because there are other statutory provisions that provide such authority.
Well, Your Honor, I think those are two different questions. One is, does an agency have authority to restrict an area? Now, what that does not mean that no one in the world has authority to declare something restricted, right?
So we're looking at a statute that says, that just talks about restricted areas without saying who should restrict them. And you're saying we should assume that if it doesn't say who's restricting them, then everybody can just restrict them. And I'm just saying, I don't know why we should assume that, because there are lots of other statutes that deal with authority to restrict things.
But we're not talking about statutes that say that nobody else can restrict something.
But you're asking us to make an assumption that anybody can restrict. And I don't see why we need to make that assumption based
Well,
on.
that's what the government argues. The government says any restriction.
No, it's a restricted area, and they're saying it doesn't speak to who can do the restricting. And their argument is, the assumption is, whoever's doing the restricting had authority to do it. And I don't see why that's not true.
Well, suppose someone comes into a deli. Suppose the president walks into a deli to buy a Coke, and the security guard in the deli says to a person, you can't go over there, it's restricted. Has he committed a crime if he goes over there? Security officer has authority in that deli.
Maybe he has.
So has that individual committed a crime if he steps into the area that the security guard has declared restricted? Under the government's view, he has.
What's wrong with that?
What's wrong with that is that it means that anybody.
No, not anybody. The security guard had authority to restrict. The security guard presumably is hired by the premises to control the premises.
So what
They
that
have the
means
authority-
is,
And maybe the security guard says, while the president is in here, like, we're not gonna let other people come in right now.
so what that means is that private citizens have the authority to set the scope of this criminal statute.
The security guard is somebody with authority. It's not just anybody in the deli.
You're making an as-applied vagueness challenge, a constitutional challenge,
Yes.
right? That's what this argument is. I mean, there are unlawful entry, trespassing type statutes that are in every jurisdiction. They're prosecuted every day. One of the elements is always, is a person on notice that they either have to leave and they can't remain in the area, or were they on notice that they could not enter the area? That's just common to all of these statutes. And the statutes don't say specifically by who. It's presumed that the notice is by someone with authority. And if you were notified and it was, and you should have reasonably believed that someone with authority notified you, then you violated the statute and there's no vagueness issue. I mean, those statutes are prosecuted every day of the week, twice on Sundays, right? What's the vagueness problem there?
Your Honor, those statutes, the trespassing statutes, breaking and entering statutes, and so on, they rely on the notion that the property that's being intruded upon is owned by someone who does not want you there. And that's different from the notion that anybody can restrict it.
All I'm saying to you is that an argument about whether someone has the power or legal authority to restrict the statute is different than a vagueness problem. You could argue they didn't have the authority to restrict it, and therefore we didn't violate the statute.
Right.
Because they didn't have any right to restrict it in the first place. That's not your argument.
Well,
Your argument is a vagueness argument.
respectfully, Your Honor, I've made both arguments.
Well, that first argument isn't a vagueness argument.
No, it's not. It's a question of what the statute requires. And the issue is, like, as we've said, the statute does not currently explicitly say if restriction must be done by the Secret Service.
Okay, and I'm saying if we don't buy that argument, then it's no longer relevant
Correct.
in the vagueness sphere, whether it's the Secret Service or whomever who has restricted it as far as the void for vagueness as applied argument goes, right?
No, Your Honor, respectfully, it is still relevant because the issue with respect to vagueness is, my argument is based on the history of the statute, the history of its use. As I said, I don't believe it has ever been used to prosecute someone who entered into a restricted area that was restricted by anyone other than the Secret Service. And that's how that's where the vagueness comes from. It's not from the statute itself, it's from the use of the statute, the history of the statute.
All right. I think we have your argument. We'll take the matter under advisement.
Thank you, Your Honors.
Case number 23-1216, Garrett O. Boyle petitioner versus United States Department of Justice. Mr. Cisney for the petitioner, Ms. Fomenkova for the respondent.
Good morning, Mr. Cisney.
Good morning, Your Honor. Good morning. Judge Wilkins, Judge Pan, and Judge Rogers. May it please the court, my name is Ben Cisney for the American Center for Law and Justice, and I'm here on behalf of FBI Special Agent Garrett O'Boyle. We're here because the Department of Justice insists that it can suspend the security clearance and employment of a whistleblower as retaliation for any reason with no judicial or tribunal review. We're here because the DOJ relentlessly seeks to defend its position that not just this court, but no one, no court, no judge or tribunal should be able to even hear an FBI whistleblower's argument of unconstitutional retaliation. There are two separate issues for this court's review, a constitutional issue and a statutory issue. First, for the constitutional question. The Supreme Court's decision in Department of the Navy versus Egan does not deny judicial review of Special Agent O'Boyle's constitutional injuries. In fact, the Supreme Court decision from this court, Webster versus Doe, allows it. This is what happens. The FBI suspends an employee's clearance, then it suspends the employee's employment without pay. You can't look at why the employment was suspended because they just say he has no clearance, and that's apparently a required aspect of employment. He has no clearance, but you can't look at why he has no clearance. Not even their position is not even the process by which they reach that decision. It's the method and process.
Why did you appeal to this court instead of the Federal Circuit?
In our view, the All Circuits Review Act allowed it, first off. But maybe more to Your Honor's question, this court's jurisprudence has more favorably viewed the exception, the constitutional exception to the Egan decision over the years, and I'd go back to the Greenberg decision in '93, the Gill decision.
So you thought our case law was more favorable to you, but the statute seems pretty clear to me that you can only be here under certain circumstances, and one of them is if you raise a challenge to a prohibited personnel practice described in section 2302 and a bunch of subsections of 2302, but that section excludes the FBI.
So I would contend, Your Honor, that well, first off, 2302(1)A defines prohibited personnel practices for the entire title, all of Title V, which includes 2302, 03, 7701, and the All Circuits Review Act, 7703. But the statute in 7701 and 7703 uses the term described in. So describing a prohibited personnel practice, essentially whistleblower retaliation or reprisal, is described in 2302. Again, for the sake of the entire title, not just the section. And the FBI is excluded from just the next section. And so if an FBI
But
employee.
I'm sorry, it's a personnel action that's taken by an agency, but then it defines an agency to mean an executive agency, but does not include the Federal Bureau of Investigation. So it seems that Mr. O'Boyle's claims don't fall within the statute.
I contend that they do, respectfully, Your Honor, because he's alleging conduct that is that which is described in or consistent with what's described in 2302. It doesn't, the 7701 and 7703 do not say, a federal employee who brought an action pursuant to or governed by or authorized by 2302. It just says if they can describe conduct, or if they raise conduct that was described in, and jurisprudence generally recognizes the distinction between described in, Congress's use of described in versus authorized by.
Even if we kind of take your point that described in might have a broader meaning or a different meaning than pursuant to, we don't just, determine what a statute means by parsing one word. We look at the whole context. And the whole context here is that Congress wanted the FBI to kind of go through a different administrative route and a different route of review than other executive department employees. That's the overall context here. So if that's the context, you have to point to some pretty strong evidence to kind of rebut that context. And I don't know that hanging your hat on the described by is sufficient.
Well, I don't hang it solely on the described in. Your Honor mentions context, and part of the context here is very much, and is reflected in the legislative history that we address more at length in our briefs. Congress was, and this goes to Your Honor, Judge Pan's question as well, Congress was displeased with the Federal Circuit in the trend of restriction of whistleblower protections. That's reflected in their legislative history, and they wanted to expand judicial review to other circuits. And one of the phrasings in the legislative history is to create a circuit split, in a sense, so that the circuits could all sort of check each other. So it wasn't just a monopoly by the Federal Circuit. They wanted to expand access to judicial review, Your Honor, after the administrative process. I concede there's a separate administrative process for FBI employees, but we're talking about.
But then shouldn't Congress have included 2303 within this provision and said that other circuits can review matters from 2303?
That was with respect to 7701 and 7703, I believe, the legislative history, making the All Circuits Review Act permanent after its 5-year probationary period.
Right. But I guess my question is just, there seems to be a separate provision and procedure that FBI agents are supposed to follow, and that's described in a different statute, which is 2303. And you're trying to rely on all these provisions that talk about 2302 by saying it's similar. But it just seems like if Congress had intended for these types of claims to be encompassed by the All Circuits Review Act, they would have included 2303.
I contend that Congress, it certainly could have been clearer, but it was clear enough in the plain language of alleging action described in 2302, which again describes it for the entire title. It was, it had to point somewhere for that definition.
But what's described in there doesn't include the FBI.
I think to points that Your Honors are making as well is that, I stand on the plain language of the statute, but if there's an ambiguity, which I understand the argument that there is, that if Congress could have done it more clearly.
If we think it's clear, should we transfer this case to the Federal Circuit?
I believe that's in within this court's prerogative to do that.
If we don't do that, you don't get an appeal, is that correct? Because all your time has run out to appeal. So the only way to preserve your right to appeal, if we think we don't have jurisdiction, is to transfer it to the federal circuit.
That's probably correct, if I'm understanding, Your Honor.
Well, it's correct that you cannot, if we decide that we have no jurisdiction and we don't transfer it, it's too late for you to appeal this ruling to the federal circuit, isn't it?
Oh, to the federal, yes. Yes, Your Honor. I believe it would need to be transferred to maintain the chain of jurisdiction.
I see.
Judge Rogers, do you have any questions?
No, thank you.
I don't know if you wanted to save any time for rebuttal. We'll give you a little bit. If you want to just wrap up.
Yes, I'll wrap up briefly, Your Honor. We asked, of course, the court to overturn the Merit Systems Protection Board decision to give Special Agent Boyle his day in court, a full day in court, so that his constitutional claims can be heard as well. And I'd like to reserve just a minute for rebuttal if I could.
All right, we'll give you some time.
Thank you, Your Honor.
Good morning, Ms. Fomenkova.
Good morning, Your Honor. Just get myself situated here 1 second. Good morning, Your Honor. May it please the court. Although in order to prevail in this appeal, Mr. Will has to run the table on all 4 of the issues that we identified in our briefing, I think the simplest and most straightforward resolution for the court is that this petition was filed in the wrong court. It belongs in the federal circuit if it belonged anywhere, but not in this court. And you know, the language in the section 7703 makes clear that in order for this court to have jurisdiction, there has to be the disposition of an allegation of a prohibited personnel practice described in section 2302B8 or a subset of B9, and actions taken by the FBI simply cannot be described in either of those sections. Section 2302 doesn't define personnel action or prohibited personnel actions for the entire title. It is quite specific. It for purposes of this section, it defines personnel action, and it defines them specifically by reference to, with respect to an employee in or applicant for a covered position in an agency, and actions taken by an agency, and the definition of agency for purposes of 2302 specifically categorically excludes the Federal Bureau of Investigation. So sort of just as a matter of the English language, actions taken by the FBI can't be described in these sections, and therefore this court does not have jurisdiction over this petition. To Judge Pan, your question in terms of whether it should be transferred or dismissed, I think that's within the court's discretion. Certainly, I think any of the other issues that were raised in our briefing would be sufficient for the court to conclude that it is not in the interest of justice to transfer the case and to just dismiss it outright. But I would agree that it would be within the court's discretion to transfer or dismiss if it agrees.
Aren't these substantial questions that, merit, substantive review by some court? So how is it in the interest of justice for us to say, no, we're not even going to transfer it so that the federal circuit can take a look at this issue?
Sure. Well, for example, one of the arguments we make is that Mr. Will forfeited or waived these arguments, and if the court were to agree with us, then there would be no reason to transfer it to the federal circuit, and they could just dismiss outright. But I do agree that I think it is certainly within the court's discretion to transfer the case if it concludes that it does not have jurisdiction.
As a procedural matter, though, what you're suggesting is that we should take a peek at the merits, even though we have no jurisdiction to do so.
Sure, and I think 1631, courts have recognized that it specifically allows the court to do that in the requirement that it be in the interests of justice to transfer the case. I believe sort of Judge Posner discussed that explicitly in the Seventh Circuit case that we cited, that requirement sort of somewhat paradoxically, but enables the court to take a peek at the merits to sort of ensure that, we're not just burdening sister courts, sister circuit courts with petitions that are going to be immediately dismissed upon arrival. So I do think the court is permitted to do that if it was so inclined.
And the peak would be from the perspective of what we think the federal circuit would do as far as applying their own jurisprudence with respect to waiver and forfeiture, right?
I think that's right. Yes, it's sort of is this would it be in the interest of justice for the federal circuit to take this up? I'm happy to address any of the other issues we raised. I don't know that they came up other than the jurisdictional one.
Judge Rogers, do you have any questions?
No, but I do want to clarify. I understood your question and I want to be sure counsel understood it that way, or I'll ask it that way. Do we apply the federal circuit law of forfeiture and waiver as opposed to this court's law of forfeiture and waiver in deciding whether it would be in the interest of justice to transfer the case to the federal circuit?
I think that probably is what makes the most logical sense to me. I don't know if that has been sort of specifically litigated, so I don't have a case in mind on that issue. But sort of just as a matter of pure logic, I think that to the extent there are any differences, it would make more sense to apply the federal circuit's case law, because that would be where it was going and that would be where that would be decided then.
Thank you.
All right, thank you. All right, Mr. Cisney, I think you only had about 30 seconds left, but we'll give you 2 minutes.
Thank you, Your Honor. I appreciate the indulgence. I'll be brief. Just a couple brief points. Is that back to the described in phrase, is that it's on its face and its plain language of the statute. If an FBI employee alleges conduct that was described in matches that which is described in some other statute somewhere else, that's enough. That on its face, that's enough, and that the interpretational aides would support that conclusion with the concerns of not restricting access to a constitutional remedy, the veterans canon, and these are other matters briefed more fully, but I just wanted to call the court's attention to that. And then secondly, to Judge Plager and Judge Lynn's dissent and the decision in Parkinson out of the Federal Circuit, there's a comment there that I think bears repeating here, and I'm quoting: "No amount of parsing of tangential statutes and regulatory provisions can justify a basic denial of the right to make one's best case to the designated arbiter of one's fate." And to your point earlier, Judge Pan, that parsing, it takes several steps to piece together the conclusion that an FBI employee can't allege conduct that was described in 2302. Where on its face, just if you just read it straight up, he can allege something and did that is what it matches what's described in 2302. And again, that's non-exclusive language. That's not, Congress knows how to specify, we only want this FBI employee to be able to access the All Circuits Review Act. If Congress wants to restrict judicial review of a constitutional remedy, it must do so clearly. With that, Your Honor, unless there's any additional questions, I'll conclude. And again, we ask the court to reverse. Thank you very much.
Thank you. We'll take the matter under advisement.
Case number 24-5004. Simon Ateba, appellant versus Karine Jean-Pierre in her official capacity as press secretary to the President of the United States et al. Mr. Dixon for the appellants, Mr. Myers for the appellees.
Morning, Mr. Dixon.
Good morning, Your Honor. May it please the court? My name is Josh Dixon on behalf of appellant Simon Ateba. Under this court's decision in Sherrill against Knight, the White House may not draw arbitrary distinctions among journalists at areas the White House is open to the press, nor may the White House regulate the press area in a way that forecloses effective judicial review. The White House's current hard pass regime violates this command in two ways. First, requiring journalists who want to cover the White House to obtain Supreme Court or congressional press credentials is constitutionally unreasonable. The Supreme Court has stated categorically it will not issue credentials to White House correspondents. And under the daily press gallery rules, to obtain congressional press credentials, journalists must show they have a need to access members of Congress. But there's no reason why a journalist who only wants to cover the White House should have to make such a showing. Second, the congressional press credentialing regime violates the unbridled discretion doctrine in three ways. One, the congressional credentialing regime gives the congressional press galleries unbridled discretion to deny an application based on their conclusion that an applicant is not sufficiently of repute in his profession. This is an utterly standard and allows the press galleries to discriminate based on viewpoint. Two, the congressional credentialing regime does not allow for effective judicial review. The congressional press galleries are not required to issue a written decision, and under this court's Consumers Union decision, the press galleries are immune from suit when adjudicating applications for press credentials.
So there's one part of this case that I'm having some difficulty with, and that's sort of conceptualizing the injury to your client, because this case strikes me as very different from all the precedents that are discussed in the briefs, in that you want to have a hard pass, but at the same time, the daily pass is available. So it seems that the burden on your client is not the typical one in First Amendment context, because most of the cases deal with licensing programs or schemes where you're denied access if you don't get this license. But here, it's really the difference between a hard pass and a day pass. And it seems to me that the difference is, and correct me if I'm wrong, under either pass, once you get into the press area, you have all the exact same ability to express yourself and conduct and exercise your First Amendment rights. But under the day pass, which is the default way of getting in, you have to apply for the pass, and then you have to wait to be escorted to the room. But you can apply for the pass, like on Sunday, you can apply for a whole week's worth of passes. So you could make that into unfettered access, except for the fact that you might have to wait to be escorted, and you might have to wait up to 45 minutes. So that's really the only difference between the two passes as far as I can tell. And then I'm wondering, is that a de minimis burden on your First Amendment right? Is that a cognizable injury that you just have to wait to be escorted?
It's more, you have accurately stated the facts. However, the injury is more significant than just a de minimis injury, insofar as because of that delay, which can sometimes be up to 45 minutes, while other journalists are filtering in to the press room, which has limited availability, the journalists could miss the ability to enter the room entirely.
Has that happened?
It has not. It has not happened that Mr. Ateba has been excluded from the room over the past year. What has happened, though, is because of that delay, and this is not on the record, but what has happened is Mr. Ateba has missed the beginning of a meeting. And I would also point out that this is a facial challenge. And so whether that has actually happened to Mr. Ateba over the last year is not relevant for the facial challenge. The point is that if World War III were to break out tomorrow, God forbid, and every journalist, and there are about 1,000 of the last evidence that we have with a hard pass, were to descend on this press room with its 49 seats and limited standing room, because Mr. Ateba has to wait for the 45 minutes, he would be excluded.
Or up to 45 minutes. How long does he typically really have to wait?
The record doesn't contain that information. He can wait up to 45 minutes. And of course, on the day where 1,000 journalists descend on the press room, he would wait at least the 45 minutes just because of the hubbub of what's going on. And so I don't think it's quite right to characterize this as a de minimis injury. This is on occasion an exclusion. It is an actual exclusion from the room.
I'm sorry, it's an exclusion from the room. How?
Because by virtue of the 45 minutes, he would not have the room would be full by the time that 45 minutes
So
had
what typically
elapsed.
happens if the room is full?
I'm sorry?
What typically happens if the room is full? What happens to the overflow journalists with passes?
I don't know that that's not in the record, but what is in the record is that there are 49 assigned seats and then there's standing room only. That would not accommodate the 1,000 journalists who have a hard pass.
It seems like that could be an important fact. If there's an overflow room where you can, I don't know, hear or.
I'm not aware of that. In the overflow room, he would not have the ability to engage, of course, with the press secretary. I'd also point out, Your Honor, that the government has admitted in footnote 5 of its brief that the exclusion from the press area cannot be based on viewpoint. And because of that admission, I think that closes the door on the argument that there's no First Amendment injury here. If it's significant enough to give rise to a retaliation
I think
claim.
it's certainly a burden on a First Amendment right because it affects access to this forum. It's just like, how much does it affect access is kind of what I've been struggling with. Is it enough of a burden for it to be cognizable
I think
in this context? And it's a right that depends on the rights that's being given to others. Because the only reason we're here is because there's two types of passes. You want the better one. And like, I just don't see a lot of analogous cases where that's the case. The closest one is this Wikimiko case, which is from the Fourth Circuit. And that suggests that where we've given you a benefit and we've taken it away and now you have this de minimis burden, there's no cognizable.
I would point out that the Wikimiko County case was not a designated press area. It was a jail, and the ACLU had been given access to the jail. So this was
Correct.
different insofar as
There
there's
was
not.
a First Amendment claim, though, that you're intruding on our First Amendment right to petition the government, et cetera, et cetera. And they said, we gave you an accommodation. It was kind of like we gave you a press pass. That's an easier way to do your thing. We took it away, but the difference between you and all the other paralegals is the same, and you're not. It's de minimis that you're now inconvenienced exercising your right.
Let me also direct Your Honor to Mansky. In Mansky, that was a case that involved the Minnesota prohibition on political attire.
Yes.
The way that statute worked was there was an election judge that was stationed at the polling place. And the judge would look at the clothing and determine whether it was political. If the judge made that determination, there was no prohibition. The individual was allowed to go in. It's just that the individual was referred to the authorities for handling. And so there was no prohibition on the right of the individuals in the Mansky case to speak. Rather, it was just a burden on the entry, delays in entry, and then the possibility of having your name reported. I could also point Your Honor to the Forsyth County case. In that case, there was a permit regime. The administrator had determined that there would be a $100 fee to cover administrative costs. And rather than pay the $100 fee, Nationalist Movement sued. And despite the de minimis nature of a $100 fee payment, the Supreme Court said, yes, we're still standing to bring a facial challenge to this permitting regime, despite the fact it's only $100.
So let me ask you where the logic of your argument takes us. There are 49 seats, and let's say there are 20 standing room spaces. So maybe you have 70 people in the room plus the press secretary. So having 100 hard passes may be the maximum that you decide makes sense under this situation. And therefore, you set up a hard pass system that has a lot of qualifications, none of which have anything to do with your viewpoint. It may be that we want people who are married or people who have 2 children. It may simply be people who are admitted to the House and Senate. or maybe the Supreme Court. It's a way of filtering without getting into viewpoint discrimination, at least as it's traditionally been defined. So here, you don't argue, and I understand why, I think, that your client's viewpoint is what's at issue. Rather, you referred to what you've been discussing with Judge Pan in terms of what's the nature of the First Amendment injury. And that's where I think we're all having trouble. And I understand from your client's point of view, it would be much nicer not to have to do this daily submission or weekly submission. And there seems to be a suggestion that if you had a hard pass, you might get called on more often. But I don't see anything to back that up. So your client does not like the fact that he has total access, but he has to do a bit more in the way of administrative matters in order to get that access. And as you point out, he may miss the beginning, or there may be a mad crush for the 70 seats and standing room that are available. But I don't see any argument here that this regime is based on some sort of impermissible standard in terms of viewpoint. Am I correct about that?
Well, Your Honor,
That's a yes or no.
we do not allege in this proceeding that the hard pass program was adopted based on Mr. Ateba's viewpoint. We made that argument below, that was dismissed, and we have not appealed that. So
That is not before us. That's what I want to confirm.
that
So
is,
there is no claim that viewpoint is at issue here.
we have,
The only claim, as I understand it, subject to your answer to Judge Pan, is there's an administrative burden, and you don't know what of repute means.
we have argued that the lack of discretion, or the abundance of discretion, I should say, the lack of ways to cabin the discretion of the congressional press galleries is de facto viewpoint discrimination because of the conclusion that
No,
other
you just told me, counsel, you were not making a viewpoint discrimination argument. I need to be clear about that. And you can't come in the back door.
we
They
have,
have said we want, and I gave you hypotheticals, people with 2 children, a boy and a girl, people who are married or only single people, or people who've only gone to public schools. There's no viewpoint in your argument. You don't like the way the Senate selects its press people or the House, and you say you have no interest in the Supreme Court, so that's meaningless to you.
our argument, Your Honor, is not that it was on this proceeding, again, that he was targeted because of the viewpoint. However, our argument is because of the lack of procedural protections in the congressional press gallery proceedings, though that lack of adequate safeguards constitutes de facto viewpoint discrimination under the Child Evangelism 4th Circuit case, the Kamanu 9th Circuit case. And so we're not alleging he was targeted on this proceeding because of the viewpoint, but that for congressional press gallery rules are insufficiently protective of viewpoint discrimination.
So I thought your argument there was your client has no interest whatsoever in covering anything in the House or Senate, which is a different argument from saying that there's something wrong with the way the House and Senate choose people for their press galleries.
Those are separate arguments, yes, Your Honor. Our first argument, constitutional reasonableness, is that because Mr. Ateba's primary desire is to cover the White House, that it is constitutionally unreasonable to require him to obtain a press gallery requirement or a congressional credential to cover Congress or the Supreme Court.
But what I'm getting at is you could make that argument the way you framed it about any set of criteria that is established for the hard pass.
I don't believe that's correct, Your Honor. For example, your example about limiting the membership to the hard pass program to those who are married. I think that would be constitutionally unreasonable. That has no bearing on coverage of the Supreme Court. Or coverage of the
Precisely
White
my
House.
point. Or people who went to public schools. That's my point. Any set of criteria, you will say your client has no interest. It's irrelevant. He wants the hard pass. And I'm just trying to understand what are the limits of your argument, or are there no limits? And the only option available to the White House for the hard pass is, I'm not sure how you would define it. Come January 1, the first 100 people to arrive at the White House get a hard pass, and that's it.
That is not our position, Your Honor. I'm sorry, I've misunderstood you until now. There are absolutely reasonable limits that the White House can place on those who are eligible for the hard pass.
And who makes that decision? Because their argument is, why wouldn't they rely on the other branches of government and just piggyback?
If the White House were to make a rule, for example, that, as Your Honor knows from the briefing, one of the requirements of the congressional press galleries is that they not be engaged in lobbying. The journalists not be engaged in lobbying. If the White House were to publish a set of standards that included not be engaged in lobbying, that would be permissible. It is permissible to restrict individuals who are there at the White House to cover the president for bona fide journalism. And if they're there to press a claim or be acclaimed.
Well, who knows what bona fide journalism means? You don't know what repute means.
The requirement that a journalist not be engaged in lobbying is a way to filter out individuals who are not there for the purpose of engaging in journalism. And so that rule would be perfectly permissible. A rule limiting, as the White House does now, for example, residents of the DC area. You know, the purpose of that, I presume, is to ensure that an individual is showing up on a regular basis. We're not challenging that. But Your Honor, again, going back to Your Honor's hypothetical, married person, that has no bearing on coverage, just like an individual requiring an individual to obtain a press pass to cover Congress has no bearing on whether they are covering the White House as a legitimate journalist.
But I mean, okay, I understand your argument, but you know, we as lawyers have to take a bar exam in order to have the ability and privilege to practice law. You know, it has lots of subjects on it. You know, I may not ever intend to work on trusts and estates or property. I just want to practice criminal law. They make me study that, learn it, pass it on the bar exam in order to practice, even though I'm not going to and have no intention of practicing in those areas. You know, life's, life's not fair. You know, he may not want to ask any questions in Congress, the House and Senate. Okay, fine. how is that a First Amendment? How is that so unreasonable that it's a constitutional violation and a facial challenge?
Well, it's not just that he doesn't want to ask questions of Congress. It is that to get the press pass for Congress, he is required to demonstrate a need for access for members of Congress. And so that's much more restrictive than just, not wanting to cover Congress. But be that as it may, we don't license journalists in this country precisely because of the First Amendment considerations and what they're doing. I don't know specifically whether there's a First Amendment right to practice law. Maybe I have a right to speak right now like I'm doing. I don't know. But the point is that the bar exam measures a lawyer's overall fitness and ability to perform the tasks of that job. Whereas when we're talking about a journalist, we're talking about speech, pure speech, in a way that knowing trusts and estates is just very different. And I know my own practice, Your Honor. While I don't do trust and estates law, there are absolutely occasions where having a baseline knowledge of trust and estates law would come in handy in what I'm doing. And so I think it's perfectly reasonable for a licensor in the bar situation to assure a reasoned, well-rounded knowledge of the profession one is engaging in. Whereas with journalism, again, pure speech, free speech, and there's no licensure in this country.
Let's switch gears for a second to go back to where we started, along the lines of Judge Pan's questioning. In a facial challenge in any context, whether it's facial overbreath, facial void for vagueness, kind of First Amendment context, there's always a substantiality aspect of it. You can't win an overbreath challenge unless because you can point out one or two hypothetical instances where, a statute might restrict First Amendment expression. It's got to be substantially overbreadth. Doesn't the precedent require us to look at this challenge that you were making in the same fashion? And doesn't that, yes or no to that? And then if yes, then doesn't that impact on whether we think that this injury is substantial enough to require us to proceed down the road of the merits, so to speak, of your First Amendment arguments?
No, Your Honor, it does not. Substantiality or substantial overbreadth is obviously a requirement in the overbreadth doctrine context, but that's not the claim we've alleged here. We've alleged a violation of the unbridled discretion doctrine. And under the City of Lakewood and similar line of cases, a facial challenge is appropriate whenever the licensing regime could result in the chill of speech or could make it difficult for the plaintiff to demonstrate actual viewpoint discrimination. And the reason for that is because an individual who consciously chooses to chill their own speech based on the discretion that's been granted to a licensor, that claim can never be brought. You can't bring a First Amendment challenge to your own chilling of speech. And so the Supreme Court said in the City of Lakewood, whenever there's an opportunity or possibility that a licensing regime will chill speech or conduct closely associated with speech, that's sufficient to bring the facial challenge. In the constitutional reasonableness standpoint, it is our position that in every case requiring an individual to demonstrate a need to cover a member of Congress is constitutionally unreasonable to cover the White House. And so our argument with respect to constitutional reasonableness is that it is facially invalid because it is facially invalid in all of its applications.
We have to look at that requirement in the context of what are the well-established, I guess, procedures of this committee, because it seems like they are allowing a lot of people who don't require access to the congressional galleries to have these passes. That's why there's a whole White House press corps that have the press gallery credential as well. And can we look at this? I know it's a facial challenge, but it says that all these rules have to be interpreted by this committee, and are they interpreting that committee broadly? Because they do credentialing for like conventions and other events that have nothing to do with access to the Senate gallery.
Well, to be clear, with respect to the conventions and other credentialing, I mean, in those situations, the press galleries are not looking to whether the credentialees are wanting to cover members of
Oh,
Congress.
so they don't apply these rules to credential those?
They do not apply that requirement that the individual, for example, if an individual wants to cover the DNC, the congressional credentialing agencies are not evaluating whether they have a need to cover Congress.
They're not required to by these rules.
That is not in the record. I can tell Your Honor that I can't remember which of the 4 credentialing agencies it is. I believe it is radio and TV. It specifically says on the website for that agency, we do not require that you show you have a need to cover Congress. The point is.
So I guess my question is, if they can do that with respect to conventions, we're going to remove this requirement for conventions. Can't they do that with respect to the White House?
Absolutely.
And aren't they in fact doing that because they are credentialing people to be in the White House press corps who are not primarily covering Congress? And isn't that consistent with the rules? Because it says the rules shall be interpreted and administered by the standing committee. So maybe they're interpreting and administering it in this well-established way.
The fact that the rules are, I mean, if the rules are in fact being administered in a way that they're not written, that's its own problem. I mean, this court said, Your Honor, in the Archdiocese of Washington case, that the inequitable or differential application of rules itself is constitutionally unreasonable. And so if they have this written requirement that they're not applying or not requiring for, esteemed journalists, that's a bigger problem because that demonstrates that they are just.
Actually, the problem that you don't like, and if they're ignoring it, you think that's bad too.
If they're ignoring it for some people, yes, I do think that's
What if
bad.
they're ignoring it for everybody? They are allowed to interpret and administer the rules and say they're interpreting this not to require this because it doesn't work as a practical matter. Like they've been doing this since 1888. They can change their ways of doing this.
I mean, if they in fact, there's no record evidence that they are doing that. All we know is that there are some members of the White House Correspondents Association who are also have their congressional press pass. But if they are doing that, then that creates its own unbridled discretion doctrine. What we know is that the rules say X. And if they're interpreting the rules in a way for some people where they're, wink and a nod, brushed under the carpet, that's its own problem.
So my issue with your unbridled discretion argument is as follows. So basically we're talking about a non-public forum, whether it's limited or non-public, it's non-public. And so the White House just has to be reasonable and viewpoint neutral. And you're saying, well, they're not being reasonable because they're farming this out to a committee that has unbridled discretion. So I kind of understand your argument to be the White House is exercising unbridled discretion because they're kind of delegating their authority, or this committee is like their agent. So the White House is exercising unbridled authority. But then you look at the rules that govern what this committee has to do, and it is so different from the cases involving unbridled discretion, where really you've got government officials who really have no limits on how they do things. And you look at these rules and they're pretty specific, and they kind of support the idea that we want people who are going to come into our White House press area or congressional gallery to be journalists, not lobbyists. So when they say bona fide journalists of repute under such rules as the Standing Committee of Correspondence shall prescribe, they're just saying, we want you to be a journalist and not a lobbyist, somebody who actually is here for the purpose that you say you're here for, because there's stuff in the record about people pretending to be journalists when they're really lobbyists, things of that nature. And it's reasonable because the White House doesn't have a credentialing apparatus. They are not the ones interviewing these people to see if they're real journalists. They're just going to adopt whatever this committee decides. Congress has also delegated its authority to this committee, and they're journalists, so they're the ones who can decide. Why isn't that reasonable? And why is it not an unbridled discretion? Because there are a whole bunch of rules and regulations about what they're trying to do and how to do it.
2 points, if I may, Your Honor. The White House does not currently credential applicants, but it did for the first half of the Biden administration. So the White House has the capability to do this. There's also the White House Correspondents Association, which.
Well, they didn't. they did not rely on Congress to do this, but we don't know what they were doing. And now they're saying, we're trying to rationalize this process. There are too many hard passes. We want you to be a real journalist. Maybe they weren't checking to see if you're a real journalist before, but now they want to, and it's very consistent with their history of doing things. There's only 2 years in which they didn't do this, apparently, in recent history. But I just don't know why it's not reasonable and viewpoint neutral, which is all we need to decide.
It is permissible, we believe, for the White House to delegate the task to, it could delegate the task to the White House Correspondents Association. The problem is, number one, that does not cure the risk of viewpoint discrimination for reasons we've put in the brief. The bigger problem with the of repute standard, though, is your Honor is absolutely right. There are 5 or 6 credentials that the congressional press galleries apply.
But it's not a freestanding of repute requirement. Of repute, under such rules as the Standing Committee of Correspondence shall prescribe, and I'm assuming that
These are the
Standing
rules.
Committee has to abide by these rules. I was curious about this, like,
These
rules are by who?
those rules were created by the committee.
Right, the Committee on Rules and Administration, not by this.
No, Your Honor, they were approved by the Committee on Rules and Administration, but they were promulgated by the Senate Daily Press Gallery.
Okay, so how come Judge Bates said we have to look at this requirement of repute in light of all these other requirements that are in this rule? And if this whole rule was interpreted and, prescribed by the committee, then you don't just look at of repute, you have to look at the whole thing.
That's absolutely correct. I mean, if an individual is a lobbyist, for example, they're out. We have no problem with that. The problem is that
But that's not unbridled discretion. There's a whole bunch of detailed rules here.
But one of the rules requires that the journalist be a journalist of repute, which basically means have a good reputation. And so because
Not
that,
necessarily, I think it means that you're a real journalist.
that's what bona fide means, Your Honor. We don't take issue with the word bona fide. Our issue is with the word of repute, which means that you have to be a journalist that has a good reputation, which it doesn't matter how many other rules cabin discretion. The problem is this one rule undoes all of that and says, if this journalist ticks all these boxes, if we conclude they're not sufficiently of
Only if
repute.
we agree with you that of repute is a freestanding requirement that is not informed by everything else in here.
That is correct, though there's no evidence that the press gallery is applying that rule to be informed by the other.
But the rule requires them to. It's of repute under such rules as the Standing Committee shall prescribe. And you agree that they prescribed all of these rules.
Yes, Your Honor, but that reads.
But of repute, it's very explicit under the rules.
We don't read it that way. We believe that the of repute requirement is its own standalone requirement.
But that's contrary to what is actually written in the rule. It says of repute under the rules prescribed by the Standing Committee.
If you look at the House rule, for example, Rule 6, it doesn't define of repute in this way. It just is its own standalone requirement. I don't believe that.
But that's not the one you're challenging. You're challenging this one.
Well, that's the one that gives the galleries authority to do this.
Okay.
Yeah, so I would also point out, Your Honor, before I let my time run too far over, that in addition to the unbridled discretion argument vis-a-vis the of repute requirement, there's also the problem that there's no possibility of judicial review. There's also the possibility that there are no timelines. And so even putting aside the of repute requirement, the Supreme Court has made very clear that when speech is being licensed, there has to be a mechanism for judicial review, and there's simply not.
Under the specific circumstances here, I can see why those requirements might be important if we're talking about a licensing scheme that says you can or cannot express yourself. But we're not talking about that here. We're talking about, can you get in 45 minutes earlier? Under those circumstances, why isn't this whole scheme reasonable?
I
just think that you have to look at the injury that is being allegedly inflicted on your client.
That takes us back to Your Honor's first set of questions, which
But I
is,
think it just informs, though, the reasonableness of all of this.
well, I would simply submit, Your Honor, that requiring an individual to wait 45 minutes and run the risk that if a significant news event occurs, they're not going to be able to get in that room with their competitors and ask the questions they're entitled
No,
to
I
ask.
understand that. And given that that is the only injury that we're talking about, it is, I agree that it's a burden on his First Amendment rights, but it's a pretty small one. I'm not sure if it's de minimis or insignificant, but it's a pretty small one. And given that that's all it is, it seems to me that all the cases that talk about time limits and things of that nature aren't really as relevant, because those are talking about, we better give you an answer, because if we don't give you an answer, you can't exercise your First Amendment rights at all. It's not that you have to wait 45 minutes to exercise them. It's you cannot exercise them at all. We better give you an answer.
On that,
That's different.
I would point your honor to the Seattle affiliate case. That's the Ninth Circuit case we cited in our brief. In that case, there was a permit requirement to march on the streets, but individuals could march on the side even without a permit. And
So what was the name of that case?
Seattle affiliate. A permit to march in the streets, no permit required to march on the sidewalks. And applicant applied and made a facial challenge. And the Ninth Circuit addressed this precise question. I don't remember the footnote 4 or 5, said specifically that even though they can march on the sidewalks, the fact that they are prohibited from marching in the streets is a significant enough First Amendment injury to give rise to these protections that apply in speech licensing regimes. We would submit that the same type of analysis should apply here. Is it a complete prohibition of speech on a day-to-day basis? It is not. But there is a circumstance under which
But
Mr.
if
Ateba.
it's a march on the street, we have to get back to you in time for you to be able to march. So that I can see why there's more of a time constraint in that case that doesn't apply here.
Potentially, although Mr. Ateba is current, I mean, he's had his application pending for 16 months. So during that time period, like I said, there have been times when he has tried to enter the room and he has been able to, but he was late and he missed the briefing. So that we believe all of that constitutes First Amendment injury sufficient to kick in these procedural protections under the unbridled discretion doctrine.
All right. Any other questions at this point, this juncture, Judge Rogers?
No, thank you.
All right. Your time is up. We'll give you a little bit on rebuttal. Let's hear from the government. Mr. Myers.
Good morning, Your Honors. May it please the court, Stephen Myers on behalf of the government. This lawsuit is an attempt to stack First Amendment doctrine upon First Amendment doctrine to ultimately invalidate a permitting system, or a credentialing system, I should say, that's been working for decades or longer to distinguish between journalists on the one hand and lobbyists or other individuals who would find it convenient to have access to senior government officials on the other. We think the lawsuit fails at every single step, whether that's the nature of the injury or the nature of the forum. But probably the easiest way is just to recognize that the criteria at issue in this case are longstanding, clear, reasonable, and viewpoint neutral. And in fact, Mr. Ateba has pointed to no time when the congressional galleries have ever abused their authority to discriminate either on the basis of viewpoint or against their economic competitors. And so, for the court to sort of agree with Mr. Ateba at every contested step of the analysis, to get to a point where the court is saying that Congress has been breaking the law for 136 years would really be quite extraordinary. And so I want to emphasize that, the requirement that a journalist be bona fide dates to 1859. This of repute requirement dates to 1888. And again, the speculation aside, we're here on summary judgments, and Mr. Ateba has just not pointed to any evidence of times when this system has broken down and hasn't worked. With respect to what the rules say, Judge Pan, I think Your Honor is thinking about it exactly the right way. So paragraph 3 of the Senate rules is sort of setting out what the role is of the standing committee. So their role is to do the screening of bona fide journalists of repute under such rules as the standing committee shall prescribe. And then the question is, well, what are those rules? And those are listed in the next paragraph. That's in paragraph 4. And those are the things like being a full-time correspondent who resides in Washington, is independent of a lobbying organization, et cetera. Again, this court's cases in Zuckerman, the Supreme Court in City of Lakewood, tells us that we can look to well-established practice. Here, the well-established practice is that legitimate journalists who want to report the news are not being discriminated against. And so, for that reason, there's no reason for this court to be skeptical of this system that has been working.
But what about the argument that you don't get any sort of written decision. There's no deadlines. It's essentially an invitation for, arbitrary action.
I think a number of responses, Judge Wilkins. One is that, again, there is no evidence of arbitrary action. That's simply not what's happening. If you look to this court's decision in the Consumers Union case, the court said the purpose of this requirement is just to ensure that, consistent with space limitations, these spaces will be used by bona fide reporters. But in terms of those heightened procedural protections to which Your Honor was referring, the Supreme Court's cases and this court's cases make clear that those are needed when we're talking about prior restraints on expression. And this is different from that sort of case, I think, for at least two reasons. The first is that no one is telling Mr. Ateba what he can say. Put aside the existence of the day pass program entirely for a moment. This is just about entering the White House. It's not saying you can't engage in sort of core First Amendment activity. But then layer on that the fact that the day pass program is available. And then you recognize that Mr. Ateba still can enter the White House. And that is further weakening any First Amendment interests that might be at play here. On that point, I want to return to an issue that the court was discussing earlier with my colleague about the burden on entering with a day pass and this 45-minute issue. If you look in the record, it's at ECF 17-2. This is an email from the press office to Mr. Ateba explaining that the escorts to enter the press facilities are available at the top of every hour when the White House is open to journalists. So, 8 o'clock, 9 o'clock, 10 o'clock, 11 o'clock, et cetera. So this 45-minute issue is only going to arise if a journalist doesn't just plan his arrival for a time when an escort is available. And so if you show up, when the escort is there, the White House.
Is there ever sort of an emergency snap, press briefing, something has happened, let's do it right now? Or is there always enough notice for this to work?
That's not in the record, Your Honor, and I don't want to represent, that doesn't happen. Just as a news consumer, my understanding is that generally they're announced in advance.
The West Wing, that happens quickly.
Exactly. But on the summary judgment record, stepping away from the West Wing, I think what I would say is that Mr. Ateba, and I think counsel confirmed this, hasn't pointed to a time when he has actually been unable to access a White House press briefing because of this fairly limited requirement.
Says he's been made late.
And again, I don't think that's in the record, but even assuming that is true, if Mr. Ateba, plans ahead, shows up at the top of the hour when an escort is available, then that problem shouldn't logically arise. But of course, this question of whether or not there is a First Amendment injury is really only the first question. And, we're delighted if the court disposes of this case at that step, but it can also dispose of this case by just saying that what Congress has been doing for 136 years is a perfectly reasonable way of doing this. What the White House has been doing for, 50 odd years is a perfectly
On
reasonable.
the nature of the injury, though, there doesn't seem to be a lot of case law that has said something like this is de minimis and not cognizable. And certainly nothing binding. I don't see anything from the Supreme Court or the DC Circuit that presents an analytical framework that says this is so de minimis, we're not even going to consider it a First Amendment burden.
I think that's fair. Conversely, as we point out in our brief, I don't think this court has said the converse, which is to say that this court's cases in Sherrill and Karam have dealt with a complete loss of access to the White House. That's not the case here. And actually, if I could return to that point very briefly, in Mr. Ateba's reply brief, he suggests that Mr. Karam in the Karam case could have continued to access the White House with a day pass. I don't think that's accurate. The complaint in the Karam case alleges that he wasn't sure if he would be able to use a day pass. And given the circumstances in that case where the White House had imposed a suspension as a punitive measure, seems highly unlikely. And it's certainly very, very different from this case, where every time he sought access through the day pass program, it's been granted.
So I think that your friend on the other side, just anticipating what they might say, would say that the denial of the hard pass is at least somewhat analogous to a prior restraint, because if you can't get into the room, you can't gather news and you can't express yourself. You can't write an opinion, or you can't, you know, if you miss the briefing, then you can't express yourself. So it's not a prior restraint in that, you know, we're banning you from saying something in particular, but it's a prior restraint, at least adjacent, because we're preventing you from access potentially to what we want to talk about, right? So what's the response to that argument?
So I think the Supreme Court's prior restraint cases are generally focused on sort of two features of the restriction. One is it is generally a content or viewpoint-based restriction. That's not alleged here. Second, it is, as Your Honor noted, a restriction on what you can say, and that is not alleged here. It is, you know, at most, a regulation of when you can enter the White House, which is not itself an expressive activity. But even if the court doesn't buy what I'm selling on those 2 points, then you get back to the fact that we have the day pass program, which Mr. Ateba, I think, acknowledges has been made available to him every time that he has sought to use it. And so those things in combination bring this case really quite far away from the Supreme Court's sort of classic prior restraint cases, where it's like, no, you may not speak on this topic on pain of punishment. Like, of course, we have really strong procedural requirements in that sort of restriction, because that is a core First Amendment value, that you not be limited in what you can say. That's just not what's happening here for a number of reasons.
Well, let's suppose the policy is we're not giving hard passes to CNN, any CNN correspondents. We're not giving hard passes to any MSNBC or Fox. They pick one or more of those and say, none of them gets hard passes. They can get day passes. And the evidence is that they can get day passes. They don't miss any briefings, but they have to go the day pass route rather than the hard pass route.
Right.
Is there no First Amendment violation there?
I think the premise of Your Honor's question, if I'm understanding it correctly, is that there is viewpoint discrimination motivating the selection of outlets. Is that correct?
Well, we don't know. They just say, we just believe that we're not going to allow any of those three network, any of the correspondents from those three networks to have hard passes anymore. They just have to go the day pass route.
So without knowing more, if the White House had a reason for doing it that was reasonable, and they weren't engaged in viewpoint discrimination, they weren't saying they don't like the tenor of the coverage, then no, it's not obvious to me that there would be a First Amendment injury. Now, the Supreme Court's cases make really clear that viewpoint discrimination is its own sort of species of evil. And so if there were viewpoint discrimination going on, I think my answer would be very different. But again, that's just not what's alleged in this case. Mr. Ateba has abandoned any allegation that there's viewpoint discrimination going on here.
Judge Rogers, do you have any questions?
I guess not, other than to observe we're not in 1859. And so the fact that it's been going on all those years, I don't know how much that persuades me, except to the extent that the burden is on the challenger to convince us that there's something wrong with what's going on. And that's where it's difficult here. I have been concerned about the fact that we don't know what will happen with the delay in getting the Senate or the House to act, where how the Supreme Court views this in terms of, is this de minimis or is it significant, substantial? in terms of a First Amendment injury, or is it just going to take the view that, you know, courts have no role in saying how the House or Senate run their bodies, and to some extent that would be true with the White House press corps? It's just a general observation, because the arguments are coming to us. Look, it's been done all these years. He's getting in. If he shows up on time, there'll always be an escort. What's the issue? It's a limited space.
So if I may, Your Honor, I think to try to take those 2 points in order. On the fact that this has been the system for a long time, that point isn't relevant in a vacuum. I'm not trying to stand here and say, well, we've been doing this for a long time, therefore we can keep doing it. I think the history, though, is especially relevant because the Supreme Court's cases tell us that we can look to, well-established practice to know if the criteria are sufficiently clear. And so when there is this long history of the congressional galleries applying these criteria in a fair, reasonable, viewpoint neutral way, that history suggests that there isn't a constitutional problem here, or it's at least further evidence that there isn't a problem here. Then on the point about the delay with the galleries, I think it's a little bit difficult for me to stand here and explain, what the status of the application before the Senate gallery is. Obviously, that's pending with the Senate, not with the executive branch. Just as a layperson, as I stand here, it's not obvious to me that Mr. Ateba necessarily qualifies under the Senate rules. And that's because, again, it is just not obvious to me that Today News Africa publishes daily, nor is it obvious that Mr. Ateba is a full-time paid correspondent for that, irregularly updated publication. So it is certainly possible that's what's going on here. I don't want to speculate more than I am, but I don't think the court needs to be that concerned, again, because there isn't that history of discriminatory application here. The evidence suggests that this is a way that works of establishing a congressional press corps and a White House press corps.
Can I just
I
get some-
appreciate your responses, counsel. And I just want to say that in my lifetime, the nature of press coverage has changed dramatically. All right. So we're talking about rules that were set up in a very different press context. And Mr. Ateba is part of that new, and by new, I mean, 40 years? Nature and all the podcasts, etc. So what is a credentialed White House press corps person is, it's just interesting to consider. And then the delay, I suppose the burden is on him to show more than incidental inconvenience.
That would be our view, yes, Your Honor.
Yeah. Thank you.
Can you help me just understand the escort policy? So if you have a day pass, you have to be escorted to the briefing room, right?
To the press area, as I understand it, yes.
To the press area. And what about once the press conference is over? Do people with day passes, do they have to be escorted? Once they leave the press area, they have to be escorted off the grounds, or can they mill about or mill around in the White House?
As it's explained in the record, and as I understand it, the escort requirement is applying on the entrance into the building. I don't understand there to be a separate escort requirement beyond that, at least based on what is in the record.
So if that's the case, in your briefing, you talk about, well, this is one way for kind of national security, et cetera, purposes. The distinction between who has a hard pass and who has a day pass. The people who have hard passes essentially get more vetting. And and that's why they can enter unescorted. But the people with day passes don't necessarily have as much vetting, so they can get in, but it's only with an escort. But if the escort is only walking them to the room, but then they can roam around the White House grounds after the briefing is over, then doesn't that just kind of make Swiss cheese out of the argument that somehow having the hard pass is important for security purposes?
I don't think so, Your Honor. The hard pass is a longer term credential. It lasts under the current policy for a year, whereas with a day pass, you do need to apply at least, every Sunday night or every day if you choose to do it that way to get access to the White House. And so the White House has determined that it's perfectly reasonable to have more criteria for this longer term credential.
But why is it reasonable to require an escort to get to the briefing room, but not to leave the briefing room?
Again, I don't want to say too much about what's required to leave the briefing room. That's just not in the record. And I don't want to get beyond the bounds of that. As I say,
Is it possible that you actually need an escort to leave the briefing room?
I have no reason to think that. I just don't think it's addressed by the record. And so I'm nervous about speculating about things that aren't described in the record. But I think the answer to the court's question, as I understand it in any case, is, why have these requirements for the hard pass that don't exist for the day pass? And I think the answer to that is just before the White House is going to give a longer term credential that doesn't require this daily or weekly application. It makes sense to be a little bit, more demanding.
I understood the question not to be having different credentials for the hard pass versus the day pass. I understood the question to be, why is this a reasonable burden if it's not imposed on both ends of the press conference?
I'm sorry, the burden being?
The burden being, why do you have to wait 45 minutes for an escort if after the briefing you can, as Judge Wilkins said, wander about freely in the West Wing?
Well, I don't think you can wander about freely in the West Wing. I mean, journalists are still subject to the conduct policy that makes clear,
Okay,
you're only allowed
an escort on the back end. Why?
I think
Why is that reasonable? Because then that 45-minute burden doesn't seem to make sense.
I think as the case comes to this court, the question is just whether the requirements for the hard pass are reasonable. And, for all the reasons I'm trying to articulate, they are.
Well, maybe the answer is it's not in the record what happens at the end of the briefing.
Well, and again, we're here on summary judgment, and I don't think that Mr. Ateba has developed the argument or the evidence with respect to that question about what happens at the end of the briefing.
Can you just give me your best response to your colleague on the other side's argument that on its face, the requirement that the paid correspondent has to require on-site access to congressional members and staff? Why is that unreasonable in the context of trying to get a White House pass?
So I know Your Honor asked for one answer. I'm going to give you two. One, I'm just not sure it's squarely presented here. I'd point the court to JA 40. This is Mr. Ateba's application for a Senate credential, where he says, "We are thrilled to inform you that Mr. Ateba will now be extending his coverage to include the Senate and the House of Representatives." So he has told the Senate he would like to cover them. Beyond that, as to why it would be reasonable in the abstract, the White House has made the very reasonable decision here that it does not want to be in the business of deciding, which journalists are sufficiently, bona fide of repute, non-lobbyists, et cetera. It just does not want to be in that business. And so it's very logical for the White House to say, well, who else does this credentialing? Who is kind of like the White House and might be able to do this? And so it landed on the other two branches of government, Supreme Court and Congress. And again, this system has been working. There is no evidence that White House reporters aren't able to get these credentials. That's how we have a body of White House correspondents.
But do you agree, though, that in delegating this task to this committee, it's as if the White House is requiring these credentials?
I'm sorry, as if it's requiring which credentials?
So the White House, like Congress, is delegating the task of credentialing to this committee. And so this committee is like their agent. So whatever rules this committee imposes are rules imposed by the White House, aren't they?
I don't think it's fair to say that the congressional committees are acting as an agent of the...
Or a delegee.
I wouldn't even put it that way. One of the points we made in our brief, for example, is that to qualify under the under the White House policy. Like, you need to be assigned to cover the White House. And so independent publications decide like which of their journalists are going to be assigned to cover the White House. But that doesn't mean that the editors of like the New York Times or the Washington Post are acting as the agents of the White House when they make those coverage decisions. It's just a simple objective fact. Are you credentialed by Congress or not? And it's reasonable to look to that because Congress has been in the business of doing this credentialing for, well over a century. I'm happy to answer any other questions or just to ask the court to affirm the judgment of the district court.
All right, we have your argument. Thank you.
Thank you.
All right, Mr. Dixon, your time was up, but we'll give you 3 minutes in rebuttal.
Thank you, Your Honor. I'd like to address first the argument that this is constitutional because it's been happening for a long time. Obviously, this is not a founding era practice. It started in 1888, not 1700s. This is not like Marsh against Chambers, where the Congress that adopted the Establishment Clause opened with legislative prayer. It started 100 years later. Obviously, there's a concept in our jurisprudence of constitutional liquidation where ambiguous provisions can be given meaning under Federalist 37. But the case law establishes that when we're talking about liquidation, what we're talking about is structural provisions of the Constitution or separations of powers like the Noel Canning case or like the pocket veto case. This is a case involving First Amendment rights. And in that setting, the Supreme Court, to my knowledge, and certainly not in the briefing, has decided that liquidation is an appropriate concept. Moreover, since 1975, individuals have been unable to challenge this press credentialing regime under this court's decision in Consumers Union. And so it's categorically impossible or inappropriate to say that the citizenry has acquiesced in this regime because since 1975, the citizenry has been unable to sue over it because Congress, the Congressional Press Gallery process is immune from suit under the Speech or Debate Clause. The government, as I understand them, they seem to admit that viewpoint discrimination in the allocation of hard passes would give rise to a First Amendment injury. I don't understand how, if that admission is on the books, which it is in footnote 5 of their brief, they can say that any other types of reasons for denying a hard pass could not give rise to injury. Either it is or it isn't. And the government has admitted that it is. It is true, as my friend points out, that there is no evidence in the record anyway of Mr. Ateba missing a meeting. But again, I would emphasize that this is a facial challenge. And our argument is that because of that possibility and the real possibility that could happen by virtue of the delay, that we don't need to establish the existence of actual injury. I would also point out that the White House.
Can you respond to that? Because I think your friend on the other side said that your argument that the requirement that the correspondent must require on-site access to congressional members and staff is not properly raised because your client said he would cover the House and the Senate.
He did in his press gallery application say that he was wanting to cover the House and the Senate. But again, he should not have to make the showing that that is necessary for him to cover the White House.
So was this litigated before Judge Bates?
This precise question, I don't recall it being raised below, Your Honor, no.
Can you just, I'm sorry, clarify? You're saying that the government has conceded that there's an injury.
That's our position. The government does not come out and say that.
But and what would we look to find such concession?
In footnote 5 of the government's brief, they admit that the White House cannot dole out hard passes based on the viewpoint of the journalist. And so if a hard pass can be denied based on the viewpoint of the journalist, giving rise to First Amendment injury, then any other reason for denial would constitute a First Amendment injury as well. We might not prevail, but we would at least have First Amendment injury based on the failure to issue the hard pass. As far as the necessity of the hard pass, I would also point out that the White House Correspondents Association took the position in prior litigation in the brief that we submitted as judicially noticed that the hard pass is necessary for any White House correspondent to cover the White House. And then finally, Your Honor, the White House, my friend on the other side says that the White House doesn't want to do credentialing itself. Again, we don't have a problem with that. The problem is when it's allocated to an entity that has unbridled discretion as part of its criteria, that make coverage of a different branch of government part of its criteria. If the White House wants to outsource.
Interestingly, it seemed to me like in my last exchange with your colleague on the other side, he seemed to suggest that the White House criteria just is, are you credentialed or not by the Senate gallery? And we don't look behind how the Senate gallery is doing that and attribute that to the White House because they're not an agent or a delegee in that sense of the White House. It's just like a box you check off, like, are you working for a bona fide publication and are you credentialed? And we don't look behind that. What does that do to your argument about unbridled discretion? I'm interested in how you conceptualize how the White House is responsible for what the committee does and what this does to your argument if, in fact, we don't look behind this box check, are you credentialed or not?
The same way that Judge Bates did below, which is to say it is constitutionally unreasonable for the White House to adopt a program that allows a decision to be made in the unbridled discretion of a congressional press gallery. It is true that the White House is not the one making the decision as to qualifications for the congressional press gallery, but it is unconstitutionally unreasonable for them to adopt a regime that allows the infection of this process with the unbridled discretion doctrine. And then finally, Your Honor, if I may, I didn't answer your question very well earlier about the Senate rules. You were pointing out that the Senate, the bona fide correspondents of repute in their profession under such rules as the Standing Committee of Respondents shall prescribe. This is not in the JA, but it is in the record. Judge Bates admitted it pursuant to our request for judicial notice. The House Periodical Press Gallery Rule 1, and I'm happy to provide Your Honors the internet citation for this.
Was this created by the same body?
This was created by the House Periodical Press Credentialing Body.
So why is that relevant?
Well, I'm going to read it, Your Honor, because it informs, I believe, the Senate daily press gallery rules because it doesn't contain that same verbiage. I mean, the concept is these rules are pretty uniform across House, across Senate, across the press galleries. And so the periodical press gallery says, persons eligible for admission to the periodical press galleries must be bona fide resident correspondents of reputable standing.
That would be relevant only to the extent that the Senate gallery relies on it, and there's nothing in the record that says they do?
There's nothing in the record that says they do, Your Honor. My point in citing this is to say that these rules are generally viewed as saying about the same thing. And the language in the periodical press gallery
If
rule
we're
doesn't.
reviewing what the Senate gallery does, just because there's another set of rules that we don't know whether they look at it or not, I just don't see how that's relevant.
Fair enough, Your Honor.
All right. Thank you. We'll take your case under advisement.
Stand, please. This honorable court now stands adjourned until Thursday, October 17th at 9:30 a.m.